Yendi of Birthright Citizenship? 2026, Supreme Court decision explained the hospital room was quiet when the baby was born. A birth that two parents, both here on valid visas, had celebrated, documented, and built their entire future around. A birth that the federal government had flagged, challenged, and was now using as the center of a legal argument that could reach all the way to the Supreme Court of the United States. A sudden knock on a door they thought was permanently closed. A bright spotlight from a legal system they thought protected their child automatically. A federal attorney asking questions that sounded simple, but carried the weight of a constitutional amendment behind them. This didn't unfold over a generation of legal debate. It unfolded in one administration's executive order, signed in the first hours of a new presidency. Hours that could erase what millions of families thought was an absolute right. Hours that could reclassify children born on American soil as legal strangers to the country they entered the world in. Hours that could end a 158-year-old interpretation of the Constitution overnight. One wrong assumption here, one belief that your child's birth certificate is enough, and the future you built could collapse in ways you are not prepared for. What the executive branch attempted crossed a line that constitutional scholars, judges, and immigrant families hoped would hold. And when that line was challenged, the courts did not hesitate. They responded with speed, clarity, and a force of judicial intervention not seen in decades of immigration law. Most people assume birthright citizenship is untouchable. They make the same mistake. They believe the 14th Amendment settles it permanently, completely, without exception. But today, you're going to understand something different. Because the legal battle unfolding right now is more complicated, more dangerous, and more consequential than any headline has fully explained. For years now, there had been signals, not from legal journals, not from court dockets, just signals, that the executive branch was preparing something that immigration law had never fully confronted. A direct constitutional challenge to the principle that being born in the United States automatically makes you a citizen. The argument had been building, yes, but also quietly sharpening in that approach. Its advocates followed a strategy, a build-up, almost a roadmap, working through policy papers, think tanks, and executive memos long before any order was signed. But what triggered alarm inside federal courthouses this year was that the arguments, once theoretical, suddenly became law, or at least an attempt at it. Constitutional scholars who monitor executive overreach recognize the indicators. The selective interpretation of the phrase, subject to the jurisdiction thereof. The argument that children of undocumented immigrants and visa holders are not fully subject to U.S. jurisdiction. The push to redefine birthright citizenship through executive action rather than constitutional amendment. The sudden elevation of fringe legal theory into official government policy. And when a constitutional argument moves from academic journals into presidential executive orders, something historic is coming. Early in 2025, federal courts detected what legal observers described as an unprecedented executive assertion, including a direct attempt to limit birthright citizenship for children born to parents without permanent legal status, not seen in over a century of constitutional interpretation. These are moves a federal administration only makes when signaling something specific. A fundamental reordering of who belongs in America by birth. A deliberate challenge designed to reach the Supreme Court. Or a political statement calculated to reshape immigration policy without passing a single law through Congress. Observers weren't sure which one applied, or whether all three did at once. But one thing was clear. The executive branch was changing its constitutional posture and doing so in a way that demanded an immediate judicial response. And when that happens without legislative backing, the federal courts pay attention in a way that is impossible to ignore. The legal challenge issued by federal judges in response was not routine. It was not symbolic. It was urgent. Court after court described the executive order as unconstitutional, overbroad, and most importantly, immediately harmful to real families whose children's legal status would be thrown into uncertainty the moment the order took effect. But legal strategy only works if the other side delays. The courts did not. Multiple federal judges issued emergency injunctions blocking the executive order before it could be enforced, and the case began moving toward the Supreme Court with a speed rarely seen in constitutional litigation. Their response was among the most decisive judicial interventions seen in modern immigration history. Now let me give you the full picture, because this story has layers that the headlines consistently miss. The 14th Amendment to the United States Constitution was ratified in 1868. It says, in part, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. For over 150 years, that phrase has been interpreted to mean that virtually every person born on U.S. soil is a citizen at birth, regardless of the immigration status of their parents. This principle is known as jus soli, Latin for right of the soil. The United States is one of approximately 30 countries in the world that still practices unconditional birthright citizenship. And for more than a century, no serious legal challenge reached the Supreme Court to alter that interpretation. Until now, the executive order signed in early 2025 instructed federal agencies to stop recognizing birthright citizenship for children born in the United States to parents who are either undocumented or present on temporary visas, including tourist visas, student visas, and work visas like H-1B and H-4. That second category, temporary visa holders, is where millions of immigrant families suddenly found themselves directly in the crosshairs. They targeted children born to undocumented immigrants. They targeted children born to visa holders here temporarily, including highly educated tech workers, international students, and families waiting years in the green card backlog. They targeted children already born, whose citizenship status could theoretically be challenged retroactively. This wasn't a border enforcement measure. It was a constitutional redefinition. And that's what made the warning so urgent for so many families who never imagined they were affected. The legal argument behind the executive order centers on those 6 words in the 14th Amendment, subject to the jurisdiction thereof. Proponents of the executive order argue that this phrase was originally intended to exclude children of foreign nationals, that subject to the jurisdiction meant complete political allegiance, which foreign citizens and their children technically do not have. They point to the exclusion of Native Americans at the time of ratification, who were considered members of sovereign tribes and therefore not fully subject to U.S. jurisdiction, as evidence that the amendment was never intended to be universal. This is the argument. Now let me tell you why the vast majority of constitutional scholars across the political spectrum reject it. The Supreme Court addressed this question directly in an 1898 case called United States v. Wong Kim, Arkansas. The case involved a man born in San Francisco to Chinese parents who were legal residents, but not citizens, at a time when Chinese immigrants were legally barred from becoming naturalized citizens. The Supreme Court held 6-2 that he was a citizen by birth under the 14th Amendment. That ruling has stood for 127 years. Every child born on U.S. soil since then has been born into a legal framework shaped by that decision. The courts blocking the 2025 executive order cited Wong Kim Ark directly. They argued, and this is the judicial consensus, that overturning birthright citizenship requires a constitutional amendment, not an executive order. An amendment requires 2/3 of both chambers of Congress and ratification by 3/4 of the states. It is not something a president can accomplish with a signature. But here is why this case is still dangerous, even with the courts blocking the order. The Supreme Court agreed to hear arguments related to this case in 2025, and a final ruling is expected in 2026. The question before the court is not simply whether birthright citizenship can be eliminated by executive order. The question, at least in part, concerns whether lower courts have the authority to issue nationwide injunctions blocking federal policy before the Supreme Court has weighed in. That is a procedural question. But the answer to that procedural question could temporarily allow the executive order to take partial effect while the constitutional challenge moves forward. And in that window, however brief, the citizenship status of children born in the United States to non-permanent residents could enter a legal gray zone that no family should have to navigate. Let me be specific about who is most immediately at risk if the Supreme Court's 2026 ruling creates any ambiguity. If you are on an H-1B visa, one of the most common work visas in the United States, and your child was born here, your child's citizenship has always been considered automatic under current law. If the court's ruling creates any opening for the executive order to take effect, even partially, even temporarily, children born after a certain date to H-1B parents could face a challenge to that status. If you are in the United States on an F-1 student visa and you have given birth to a child here, your child is currently a citizen by birth. That status could be challenged under the policy the executive branch is arguing for. If you are here on a tourist visa AB1 or B2 and you gave birth during your visit, your child's citizenship is the specific target of this executive order. So-called birth tourism was the stated motivation for the policy. But the language of the order does not stop at tourist visa births. It sweeps in anyone without permanent legal status. And that includes millions of people who have lived in this country legally for years, waiting for green cards, building careers, raising families who never imagined the citizenship of their American-born children would be questioned. Now I want to talk about what you should do right now, because preparation is not panic. Preparation is protection. First, if you have a child born in the United States, preserve every document that establishes the circumstances of that birth. The birth certificate is the primary document, but also keep your visa records from the time of the birth, hospital records, and any federal documents that show your legal status at the time. If the law changes and challenges to existing citizenship are attempted, documentation of legal presence at the time of birth will matter. Second, if you are currently pregnant and in the United States on a temporary visa, consult an immigration attorney now about what a change in the legal landscape could mean for your child and your family's plans. Third, do not assume that because courts have blocked the executive order, the issue is resolved. It is not resolved. The Supreme Court will issue a ruling in 2026. That ruling could uphold the injunctions. It could also narrow them or create new legal territory that has never existed before. Fourth, if you are in the green card backlog and have been for years, this case is a powerful reminder of why adjusting your status remains critically important. Permanent residency changes your child's legal exposure completely. Fifth, follow this case actively. The Supreme Court's 2026 decision on birthright citizenship will be one of the most consequential immigration rulings in American history. Every immigrant family in this country, documented or undocumented, temporary or permanent, has a stake in what that decision says. There is one more thing I want to address, and it matters deeply. Some people watching this will hear the government's argument and feel fear, not because they agree with it, but because they know how these things can move. They know that laws change. They know that what was once guaranteed can become contested. They know that the immigration system does not always operate on logic or precedent alone. That fear is valid. And the answer to that fear is not silence. It is documentation. It is legal counsel. It is community. It is knowing with precision what the law says, what is being challenged, and what you can do right now to protect your family within the current legal framework. As 2026 continues, more details will emerge about what the executive branch hoped to achieve with this challenge to the 14th Amendment. More rulings will come. More families will need to make decisions based on a legal landscape that is moving faster than anyone expected. But one thing is already clear. Knowing this right now does not make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family from a legal shift that is not theoretical. It is being argued before the highest court in the land right now. Share this video with your family. It might save their life one day. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.